Good afternoon, everyone. Welcome for coming on to this. Just a very quick introduction. We originally tried to organise this seminar back in November, but we delayed it thinking there'd be more clarity on exactly where we'd be. I don't think we've got it. There is still the negotiated deal. There's the no deal and there's the no Brexit. And we've just found today that the next meaningful vote is on the 29th of January on Plan B, whatever that might be. So having Stephen Sidkin and Sasha Schoenfeld from Fox Williams to give us some guidance at this stage, it would be really helpful. I'm sure we're all at different stages of preparation, but this can only help.
Jeremy, thank you very much indeed. So my name's Stephen Sidkin. I'm a commercial law partner at Fox Williams, and I'm going to be talking about Brexit, nerves of steel or brains of straw. And brains of straw is a euphemism. I could have described it as something else. It's actually taken from a title. It's not original. Very little of what I have to say is original. But it's actually taken as a title from an article which appeared in the Times about 3 months ago, and was a description by the writer of how the writer felt about a large number of members of what was then the cabinet. And I say what was then because every few weeks or so it is a moving feast. And why does it all matter? Why? Well, I'm going to turn to start with to refer you to a couple of things. One's been in the news. This is a printout of the item which I think appeared at the end of last week. In fact, it did appear at the end of last week in the Times. For those of you who can't actually read the headline, it says, European Medicines Agency case against Canary Wharf threatens property market, quote, disaster, end quote. And a couple of things are worth bearing out. The European Medicines Agency, which is located in Docklands in Canary Wharf, is seeking to get out of a lease that it entered into in '95, and is seeking to do so on the basis that with Brexit, if Brexit happens, the UK will leave the European Union. And I quote, the Medicines Agency argues that after Brexit it will not be able to operate from the UK because under EU law it must be located in a member state in order to be eligible for immunities and privileges granted to EU decentralised agencies to preserve their independence. Canary Wharf Group's lawyers will dispute this and say that under the terms of its lease the agency is able to sublet the space. In other words, what's the problem? And it goes on to quote one of our competitors, so I won't tell you the name of the competitor, but it goes on to quote one of the competitors who says, if the Medicines Agency is successful, and depending on how wide the court opens the floodgates, that could have disastrous consequences not only in the property market, but for the UK economy as a whole. It is possible that all sorts of contracts, well beyond leases, could be frustrated by Brexit. And I'm going to talk about the subject of frustration and contracts being frustrated in a little while. But the other reason, or the other item to bring to your attention at a very early stage, is a government paper. This is available free on the relevant government website. For those of you who can't see the title, it says Customs, Excise, VAT and Regulatory Changes you need to know about if there is no deal. And it says, and I'll just read you 2 paragraphs which start to put things in context. If the UK left the EU, which seems to me to be slightly odd given that this paper was written in December, if the UK left the EU on 29 March 2019 without a deal, there would be immediate changes to the procedures that apply to businesses trading with the EU. It would mean that free circulation and movements of goods between the UK and EU would end. From 11 p.m. on 29 March 2019, for businesses trading with the EU, the impacts would include Businesses having to apply the same customs and excise rules to goods moving between the UK and the EU as are currently applied in cases where goods move between the UK and a country outside the EU. Two things. The impacts would include. Whenever lawyers see the word include, they're immediately on alert, because include says that's a non-exhaustive list. It's a red flag to a lawyer. There are bells going, or there should be bells, going off in the lawyer's head. Second, last autumn there was a report that 140,000 businesses in the UK do trade cross-border. They do trade internationally. They trade with businesses elsewhere in the EU. So leave aside those businesses that trade, either they're buying or they're selling goods to businesses in the EU and outside the EU. Leave those to one side, because those businesses will have knowledge, they will have understanding, they will have been through the process of filling in customs declaration forms, filling in the forms that need to be filled in, or engaging import agents to fill in those forms where they're bringing goods into the UK. 140,000 businesses in the UK have only ever traded, insofar as they trade internationally, with businesses elsewhere in the EU. They would not recognise a customs declaration form if it came up and smacked them around the face. I'm not sure I would. I'm going to touch on some key Brexit process dates. Exit date, irrespective, 29 March 2019. Why irrespective? Because we do have, at the moment, an EU Withdrawal Act. It's an act of Parliament. It is part of our law. It has come into force. And one of its provisions says that the UK will leave the EU 11 p.m. 29 March 2019. Two things from that. The first is that as an Act of Parliament, it can only be changed by, because of the way it's written, it can only be changed by another Act of Parliament. That means there has to be legislation going through Parliament in order to make sure the UK does not leave 29 March 2019 at 11 p.m. And if, for some reason, and I can't think how or why, it is not possible to put through amending legislation, that is it. As a matter of law, and in this country we do abide to a very considerable degree by the rule of law, as a matter of law, if we do not put through amending legislation, that is it. The EU, or the EU 27 as will then be, can do anything they want. Putin, if he wants to, can fire underwater drones at us, which has been in the news recently. It doesn't make a blind bit of difference. The law says we leave unless the law gets changed. And the second thing to mention is this. So far as that particular law is concerned, the EU Withdrawal Act, and when it says we will leave, it's all very well for us to put through amending legislation, but of course, we've got to rely on the EU 27, as will then be, being prepared to, for example, extend the period of notice given under Article 50 of the relevant legislation, relevant EU legislation, which is the TFEU, Treaty on the Functioning of the European Union. So, exit date irrespective, at the moment, if we carry on where we should have been, presupposing that the UK-EU withdrawal agreement had been approved. It hasn't been, but who knows, it may still end up being approved on a further vote in a modified form. 31/12/20 is when the transition deal end date, or the transition deal ends. What does that mean? It means for businesses, because that's what we're concerned about here, it means for businesses that the UK remains effectively status quo ante. So what exists today will continue to exist, say on the 30th of March 2019 through to 31/12/20. A large number of businesses would prefer, A, the whole thing went away, B, don't worry, it's all going to happen, it's all going to be sorted out, there'll be no problems. I wish our litigation partners will think that it is Christmas, Easter, Rosh Hashanah, Eid, Diwali, everything all rolled into one. At the moment, what do we have? We have a Prime Minister. There you go. A Prime Minister, apparently. A Prime Minister trying to do all these things, all at the same time. Good and luck are two words that come to mind. And not least, discussions with senior parliamentarians, or more particularly, in one particular case, in making an invitation to a particular senior parliamentarian and being told to go boil her head, was, I think, the response. And I paraphrase. And with devolved Scotland and Northern Ireland administrations, and I put Northern Ireland in square brackets because at the moment there is not a Northern Ireland administration. The Democratic Unionist Party might think that there was, or might hope that there was, or not, as the case may be, but there isn't. So that is what that is what's trying to happen all at the same time as just running the country. But to go back to your point about the lack of sufficient licenses, if it were just that.
That's not just that, that directly affects my
If it were just that, would it be manageable? Not really. But when you think of everything else, why is that the case? Well, essentially it's the case because for over 45 years now, the UK has been a member of the EU in various guises, whether it was European Economic Community or latterly, and then that morphed through the single market to the European Union. Our laws are enmeshed with those of the EU. A large proportion of the laws that I deal with are EU-derived laws. A significant proportion of the law that Sasha deals with is EU-derived law. And so what you're seeking to do is to take apart, from our perspective, take apart, untangle, unwind 45 years worth of law because of what we may end up doing. Move on. What are the no-deal issues? Well, statement of the bleeding obvious, a very significant impacts forecast. Imposition of World Trade Organization tariffs and HM government contingency planning. Well, contingency planning, one could say that. I'm not sure that they're actually doing it, or doing it sufficiently. And when I read the paper they put out about customs duties, I really wonder how much value they're adding to the situation. There are various so-called briefs which the government has put out, which tell you various things, or try and tell you various things: trading with the EU, exporting control goods, VAT, trade remedies, classifying goods in the UK trade tariff. And everyone in this room is involved in running, in one way or another, either the whole or different parts of their businesses. And you've all got enough to be getting on with. I've yet to meet someone in business who's got a lot of time, if any time, on their hands. And then you've got this on top. Good luck. So what do we have? We have the European Union Withdrawal Act 2018, to which I've already made reference. Initially, it was called the Great Repeal Bill because someone thought it would be good to try and suggest that it was in some way comparable to, I think it was the 19th century, pretty sure it was the 19th century Great Reform Act. The bullet points tell us what it is supposed to be doing. Royal assent was given last June. Will we have a withdrawal agreement? Couldn't tell you. Well, I could tell you, but I could tell you what I think. And in fact, yesterday I decided to really stick my neck out, and I had a bet with my son, who's closer, I think, to these things than I am. His view is that there will be a deal, that there will be some form of withdrawal agreement in place. I think there will be a hard Brexit. That's what I think will happen. Not because we want it to happen, but in a way comparable to August 1914. I think we will get there. What I'm going to be talking about now are various issues which lead through into hard Brexit and what we need to be thinking about. Very briefly, this is part of the issue. For those of you not familiar with the historical issues, happily chat during coffee break or over drinks later about the issues involved and why it is as it is. But in brief, it's two interlocking unions. It is as if, try and do this properly, it's as if you're trying to break that. Because the United Kingdom is a union. England, Wales, Scotland, Northern Ireland. It is a single market. Okay, if you go to Edinburgh, Glasgow, anywhere north of the border, yes, you will get £5 notes, £10 notes, 20, 50s with Bank of Scotland on them, but they are legal tender both sides of the border. But it is a single market. There is free movement of goods, there's free movement of services, there's free movement of capital, there's free movement of persons between the UK, or between any part of the UK and any other part of the UK. And that has been the case for centuries. And so you have that union interlocking with another union, which is the European Union, and you have the about 500 kilometres of border, starting from the southeast through to effectively the north, which is the border between Northern Ireland and the Republic of Ireland. Why do I mention Chris Heaton Heath? I mention Chris Heaton Heath. He is a junior minister in the Department for Exiting the EU. Last November, I attended the executive committee meeting of a trade association where I'm counsel to the executive committee. He was one of the speakers. He, at that time, was confident that a deal would be struck with the EU, so he got that spot on. He was also absolutely confident that what was agreed with the EU would pass through Parliament. He got that absolutely wrong, or at least wrong on the first vote. He struck me at the time as being the sort of guy, and never met him before, never spoken to him, no knowledge of him. If you'd asked me who are the junior ministers in the Department for Exiting the EU, I'd struggle. Just about recognise the Secretary of State for Exiting the EU. But he struck me as a sort of politician who believes, and he will probably say that I'm doing him a disservice, but it's as I see it, that if you say something often enough and loud enough, that it will happen. And he was saying it will happen, it will happen, it will happen. He was, to be fair, he said it's down to politics. And it is, to a very considerable degree. Everything that we face, or have faced and will face going forwards, is to a certain extent down to politics. There are other things which are not. There are other things which are not. For example, a fundamental issue is the law of the European Union. It's fundamentals of the four freedoms: the free movement of capital, labour, goods, services. The fact that there is a single market, a union of the European Union, and it is because of this interlocking that we have an issue. So the UK-EU Withdrawal Agreement Bill, that was what sought to be passed. The meaningful vote, well, that resembled pretty much the first conversation that happened in December 1903 when Oliver said to Wilbur, "This thing will never fly." And then ultimately it did. So who knows, when it comes back, maybe it will fly. If the withdrawal bill is finalised, in other words, if the UK-EU withdrawal agreement gets through Parliament, then this is what's going to happen. And effectively, for the period between, let's say, 1 minute past 11 p.m. on the 29th of March through to midnight, or in fact 11:59 p.m. UK time on 31 December 2020, this is what's going to be in place. And that is why, to a very considerable degree, it will be the status quo just carrying on. There will be time for businesses to prepare. That's the most important thing for whatever happens after that. This is the UK trade bill. It's intended to put the UK in a legal position where after we have left the EU, We can negotiate our own trade agreements. We need legislation to do that. The UK trade bill was, note past tense, was going through Parliament. It's now stalled. We've got the cross-border taxation customs bill. Yes, I know I ought to get out more. And that is not dependent on ongoing negotiations. But we come on to what I think is important, and this sets us up for the second part of what I'm going to talk about. The two quotes you see at the top of the screen, these are quotes from a managing director of a business in Scotland. These are not me, these are not made up, these are true quotes. The business itself is in the, if I remember it correctly, is in the bathroom industry. And this is what he said. If we can't agree the terms of a free trade deal, a hard Brexit will follow in March 19. If we can't agree the terms of a free trade deal. He then went on to say, if there is no deal, goods will simply not get into the UK. At some point, the WTO, the World Trade Organization, would intervene and goods may trickle through with tariffs applied. Some businesses are making plans. There are well-publicized examples of some businesses that are making plans. They have taken in extra stock into the UK. I'm told that warehouse space in the UK at the moment is at a premium. I'm told that logistics companies, fulfillment houses, again think it's a mixture of Christmas, Easter and all the rest of it rolled into one. Most are not. Most are not making plans. So why do I say these are misconceptions? There's a lack of understanding. If we can't agree the terms of a free trade deal, what has been discussed up until now for the purposes of the UK-EU withdrawal agreement is an agreement for the terms on which the UK will leave the EU. And if you think the last, pretty much the last 18 months have been fun, and I use the word fun in a loose sense, you ain't seen nothing yet when there comes to be discussed the terms of an ongoing trading agreement between the EU and the UK. There has been no free trade deal discussed other than, I suppose, to some extent replicated in the political declaration which accompanied the withdrawal agreement that was signed by the leaders of the 28 member states and President of the Commission, President of the Parliament. But there has been no free trade deal done as yet. And then if there's no deal, goods will simply not get into the UK. Goods will get into the UK. They may not get in the way we would like them. There may well be delays. When I say may well be delays, I will put money that there will be delays. We've had the example already that there are not enough licenses going around. But to believe that at some point the WTO would intervene and goods may trickle through. The WTO is not some form of emergency roadside assistance service. There's a hope that Brexit will just go away. A belief that if it does not, the effect on businesses will be manageable. There's more information at the main Fox Williams website, foxwilliams.com/Brexit-lawyers. Moving on to the second part and running through it, there's always been a need to review periodically important business contracts or agreements. Yes, we've all got lots of things to do, but to believe, certainly as some of our clients believe, that if they don't sign an agreement that's sent to them, therefore they don't have anything to worry about, is la la land, with apologies to Ryan Gosling. It really is. English law says, well, first of all, English law, there are very few agreements which English law requires to be in writing. Very few indeed. There are even fewer that English law requires to be signed. Agreements can be in place simply by conduct. They can be in place orally, or if someone sends you an agreement and they just put it in an electronic folder and do nothing with it, and then effectively the parties abide by the terms of that agreement's going to be in place as a matter of English law. So what I go on to say is that the vote on Jan 19 put the needle into the red zone on the rev counter in terms of reviewing agreements. And the starting point is not to look at all your agreements. The starting point is to work out what is important. Most of you will be familiar with the 80-20 rule. The chances are that 20% of your agreements represent 80% of your business. Chances are. Consideration should be given to the effect that Brexit will have on suppliers, on customers. Supply chains may also be affected by cash flow or continuity problems. I use may, the conditional, the possible may. Do not be surprised if some businesses that you are dealing with post 29 March, presupposing a hard Brexit, emphasise that, tell you that they're experiencing cash flow continuity problems when they're not. They're simply seeking to take advantage of the situation in the same way that Canary Wharf's lawyers believe that the European Medicines Agency is seeking to get out of a very long, relatively expensive lease deal for some offices down at Canary Wharf. And so a contracting party may seek to end or renegotiate an existing contract which it has with you, reference back our litigation partners who are looking forward to this. Consider geographic references such as territory that may be EU specific. Often we see, or I see, agreements which refer to the territory of the agreement being the European Union. But what is that? Time for a little bit of interaction. Hands up all those who believe at the present time, not what may happen post 29 March, the Channel Islands are part of the EU. Isle of Man, part of the EU? No? Okay, you're good. Gibraltar?
Yes. Yeah.
That's a hard one, it's got special status. Canary Islands?
No.
Hey, oh, okay, I'm impressed. Thank you. Essentially, the point is this. Terms are used in agreements, often they're used where people have not actually given thought as to what they're writing down. Prime issue when it comes to the issue of territory is what actually is the territory? And things move. I can remember in the 90s, possibly early 90s, I can remember looking at an agreement which said the territory is Yugoslavia. Yeah, indeed. I can remember looking at agreements where the territory was Hong Kong before it became an SAR, so far as the PRC is concerned. So does the contract require compliance with a specific piece of EU legislation? Check whether the agreement is likely to span the formal exit from the EU, whether the change will affect interpretation of the agreement. This is particularly important when it comes to the duration, the term of the agreement. Because if it is spanning the formal exit, then you need to work through the agreement, you need to look at your counterparty, you need to work out where the balance of the contract lies. To what extent do they need you? To what extent do you need them? And though time is short, it may be preferable to try and change various provisions such as the renewal date or include contingency arrangements. Again, although time is short, consider long-term contracts, fixed pricing. A few years ago, I was advising a chemical company. It was a supplier to a water company in the northern half of the United Kingdom, without trying to narrow it down. And this particular chemical was absolutely vital for water supply. If this chemical did not go into the water supply system, then we were without, or this particular part of the UK was without drinkable or potable water. Okay, except the contract that it had entered into was a long-term supply contract at a fixed price, and the spot market had moved against it. So it had agreed to supply at, I don't know, but let's say £100 a tonne, and it almost certainly wasn't. and the spot price was at least 150 a tonne. In other words, every tonne it supplied, it was losing £50. It wasn't a question of what's its margin, it's a question of what's the impact on its overall bottom line, because fortunately this wasn't its only contract. So our advice was, how do you get out of that contract? Foreign exchange inflation issues may also have an impact on pricing and payment structures. Almost another statement of the bleeding obvious. I was in New York on business just before Christmas. I was previously in New York in June of last year, and in that period of time, 6 months, I had noticed, or I did notice when I was there in December, the impact of the currency exchange movement, the US dollar against sterling. Things have got a lot more expensive. There are likely to be supply chain delays. Where will we end up? I do not know. Is it single market? Is it customs union? Is it WTO insofar as it can be WTO? Who knows what it's going to mean for pricing and tariffs? There are going to be contractual issues. There's going to be an issue of force majeure. The European Medicines Agency is a prime example of that. Although I would argue it depends who we're acting for, query the ability to rely on force majeure. Force majeure is intended to cover the situation where something falls from the sky, the unexpected. Hands up, anybody in the room who hasn't been aware of the subject of Brexit for the last 30 months. Yeah, exactly. Material adverse change, you generally find those sort of provisions in construction contracts. It is something that can be considered going forwards, particularly given what we don't know at the moment as to where we're going to end up. Unlikely you'll find them in many contracts that you have entered into up until now. Rules of origin, for those of you involved in exporting or importing goods, there will be issues concerning rules of origin, for sure. When I was in New York, I spoke to one individual a fascinating guy, partner in a law firm. Law firm is devoted to dealing with issues arising under US customs law. And if you think I'm sad, but this guy was explaining to me, there's just one example he gave me. US customs law operates on the basis that if you import an air conditioning plant into the US, you will pay duty at that level. If you import the plant in 2 parts, you'll pay duty at that level. And okay, you'll have the assembly costs in the US, but still the benefit will flow through. There will be issues of duty and rules of origin going forwards in the absence of there being some form of customs union. I have to pick my words carefully to avoid criticism from either sides of the political divide. Some form of customs union going forwards. And there will also be transfer pricing issues. So if you've got your company in Estonia, and your company in Estonia is supplying goods which have been contracted for in, say, China, query whether there's going to be a transfer pricing issue. Tax authorities, both on this side of the channel and on the northern border between Northern Ireland and the Republic of Ireland, and those in the EU27, will look at how things are happening in order to increase their tax take. Of that, I'm absolutely confident. Termination. Agreement may contain a clause that provides termination rights in the event the UK leaves the EU. Brexit may also fall under the general provisions relating to material adverse changes, or force majeure, I've just mentioned that. Frustration could also apply, and that's the argument which is one adopted by the European Medicines Agency. Governing law and the clause dealing with how disputes are to be resolved essentially do not work on the basis that simply because it says English law that you're going to be fine. You should be, simply because it says the English courts will have exclusive jurisdiction. Hopefully we will end up in a position where there are no problems, but can I guarantee it? Most definitely not. For those contracts that are important, thought needs to be had before you press the termination button, otherwise known as giving the Article 50 notice. So, I've spoken for about the last 40 odd minutes about things which I think are very serious, arguably very sad. I'm now going to conclude my talk. I'm going to conclude my talk by bringing to your attention a couple of things which I think are very amusing and really the only things that have kept me sane over the last few months. This is something that was written by Matthew Parris. He's a columnist in the Times. He's a former MP. He was an aide to Margaret Thatcher. And he wrote this back in around about May, June last time. I enjoy it. Apologies for those of you who may be offended. Hope for the best, prepare for the worst. Nerves of steel, brains of straw. That's it for me. Not least because I'm about to lose my voice. If you've got any questions, any issues, happily take them.
I've got one question.
Yeah, go for it.
I import into the UK a substantial amount of material every year.
Yeah,
I also sell that material into Ireland.
yeah.
So that's a challenge from two fronts. And I'm just interested to know from your recommendation how you deal with that.
And is it the same that you import that you sell into Ireland?
Yeah, so it's distribution.
Right. And you're not doing anything to the product whilst it's in the UK?
No, I'm stocking it.
You're stocking it, you're supplying it to customers, I guess, in the UK and customers in Ireland?
Yes.
Right. And depending upon what it is in terms of quantity and what it is in terms of value, and I say that because there can be a huge disparity between quantity and value. Would there be value to you, or you may wish to explore whether there might be value to you in setting up a company in Ireland and bringing the product directly in to the Republic of Ireland?
Now, from a distribution point of view, that wouldn't work.
Why?
Because we deliver to Ireland once a week, and it's not like it's full shipments of material coming from our partners in
Right,
in
so
Ireland.
that then starts to give you the answer, which is you've got a problem.
Yeah.
Under that EC.
Other than we may be in a
Can't
situation.
direct ship from Europe to.
Yeah, I get that. Other than we may be in a situation where, although there are at least 10 or 11 members of Parliament from the DUP and quite a few members of Parliament on the Conservative benches who probably put me to the stake for this, we may end up in a situation where Northern Ireland has effectively a status vis-a-vis the EU, which is not the same as the rest of the United Kingdom.
Okay.
At which point there may be value in setting up a company in Northern Ireland.
Right. But we're not to know that yet. That's the problem.
I tell you, if you know the answer, I'm off to Ladbrokes. I'm going to put some money down.
And just one other thing, what you haven't mentioned, a lot of people don't mention, is I'm always intrigued to understand what's on the other side of the fence, what our European partners are thinking of goods coming from the UK into the EU, and are they as nervous as us? And surely, if they're as nervous as us, then they'll be putting in things to counteract that.
That's a very good question, and I haven't touched on that. Earlier this week, I read that the German upper house of Parliament, the Bundesrat, has put through legislation designed to allow UK businesses that have got UK companies registered in Germany, and they are, I think, and I had no idea, I think there are about 8,000 UK businesses which have UK companies registered in Germany. So these are UK companies, and they are registered in Germany to allow them special status.
Bypassing the EU
Under German law, they have special.
German law.
So they will continue to have special status, notwithstanding Brexit.
Okay.
So they have had special status under EU law, and irrespective of Brexit, they will have special status by reference to this German law. Last autumn, I was reading about how the Dutch government in particular has been holding a series of seminars throughout the Netherlands designed to bring Dutch businesses up to speed with what is happening, what they can be doing, what they should be thinking about. Generally though, outside of particular industries with very complex supply chains, think automotive, think aeronautic, possibly pharma, most EU businesses, other than UK businesses, so the businesses in the EU27 have not been thinking about it. They too, this is good news to a degree, they too have been adopting the position of the ostrich. Meanwhile, the equivalent of our litigation partners in law firms across the EU27 think that it's critical and so on. So they're very happy.
Okay.
You can't even, our drivers that we have can't even drive into Europe because they don't have the IDP forms. I've been to 3 post offices, which are only 90 out of several thousand that are meant to have these forms. And I've been to 3 of them and none of them have the forms. So you can't even legally drive Ireland.
Yeah.
So you can't go on holiday there.
Oh, and sorry, one other thing that I do know is that the warehouses and facility or fulfillment operations in mainland Europe have seen an upturn in business, for sure. By way of comparison, one of our clients has asked us to look at an agreement. They are a non-European client or non-EU client. They've asked us to look at an agreement with their warehouse and fulfillment supplier or supplier of warehouse and fulfillment services here in the UK. Why? Because they think they're being taken advantage of, and they are being taken advantage of. Why are they being taken advantage of? I think because the supplier thinks they can take advantage. Where are they going to go?
Yeah.
And so our client's saying, what can we do about it? Which is why in my department, forgive me for those of you who somehow like Boris Johnson, in my department we get through virtually a hell of a lot of Mr. Sheen and a hell of a lot of put my teeth back in, pledge. We are always polishing. Sorry, any, yeah.
Sorry, did you? So as a UK business, in fact we're setting out actually to start trading through a UK company.
Yeah.
But we're going to be selling to European businesses. And the goods that, so we're a signage and branding business.
Mm-hmm.
So some of our goods will come from Denmark,
Yes.
which is our home, and some of them will come from Latvia or other European countries.
Yes.
But if I'm selling to another European country, I'm really confused about what that means. Does everything actually have to come to the UK and then I ship back out?
No. No. It would.
Services that go on top of that when they do.
Yeah.
It's not just
So, so far as the goods are concerned, the goods will be in free circulation. So, as I see it, that will mean that you will avoid going through forms that you would otherwise have to go through, which is something I touched on earlier on. You'll avoid the issues which our colleague here has referred to in terms of not being able to get the permits because there's a quota, not being able to get drivers to drive because they don't have the relevant forms. Query what's going to happen when you come to bill.
Yeah.
Good luck with that.
Yeah. You could help.
I wish, no. Whether it's going to be a situation, as I suspect it is, that there will be a separation out of the value of the services that you have provided, and that will be subject to some form of customs charge. But the goods will not be, because they will be in free circulation in the EU27. I do not know. I do not know. I wish I did.
Can't charge a commission to the holding company in Denmark.
Well, leave aside the fact that you're separating out. If you weren't separating out, query going and looking at the situation and working out what is the best way forward. But at the moment, it's a devil's own job because we don't know where we are going to be. What is the case is that at the moment, if you take my view, which is we're headed for a hard Brexit, and as I said, my son takes a different view, and I hope I'm wrong, and he wins the bet. What we have experienced, depending on how long you've been in business, for the last 45 years, is going up in smoke. It's as simple as that.
I'll just say, so we have a lot of goods coming in from Europe.
Yeah.
We sell chairs and furniture. So we'll have a chair coming from Italy, a chair from Poland, a chair from Portugal. We bring it into London and consolidate the order into London, and then we'll deliver it to the end customer, possibly in the UK, possibly in France or Paris. You know, we'll bring it into the UK from Europe and export it back out again. Yeah. Presumably, after the end of March, that's going to be a ludicrous way to do business.
Well, it depends. It depends whether or not we have a transition deal. It depends whether or not ultimately, well, it depends whether we have a transition deal. We only have a transition deal if there's a withdrawal agreement in place. And then it depends upon what trading relationship we have with the EU 27 going forwards. Don't know. But it may make sense in the same way we were discussing a few minutes ago about setting up a business, a company in Northern Ireland. It may make sense not to bring the goods into the UK. It may make sense to have a operation in, let's say, think of a generally tax favourable environment, Netherlands, that you have some form of operation there. The goods are in free circulation. You consolidate your EU 27 orders there, and those that would otherwise be for the UK are for the UK.
And second question, we've started getting emails from suppliers. So I got an email from a supplier in Poland the other day saying, please avoid any deliveries in April because we're not sure what's going to happen. Yeah. Is that a ridiculous email?
No.
Or, you know?
It's called a CYA email. Exactly, which goes back to my friend the ostrich. We advised last week a UK software company. The UK software company had received a communication from one of its suppliers. What this communication said was to the effect, and I will paraphrase, as you know, Brexit's due to happen. Whilst we will try and make sure that you suffer no inconvenience, it's possible that you will suffer inconvenience, but we'll do our best. Love and kisses. Let's hope West Ham beat Bournemouth on Saturday, and I'm a West Ham fan. That's essentially what it said. And our client said, one, what does this mean? And two, should we be doing the same? So what does it mean? It means that the supplier is trying to set itself up to avoid liability. That's what it means. The supplier is trying to say, but there's Brexit. We told you Brexit, force majeure, thing that fell from the sky. And therefore we shouldn't be liable. Whether or not it is capable of operating depends upon the terms of the contract. Otherwise, it may be something you could try and get away with to cover your with. Chances are, in my view, for most business contracts, it will not work. For our client, the software company, to do the same, well, it's worth thinking about, depending upon the contracts that it has, and we've said this to them, that it has with its customers. But I suspect we're going to see a lot more CYA letters or emails being written as people think, well, what do I need to do? What can I do? Will it work? Will it fly? We go back to 1903.